The Honorable Segona says bad faith. The word is bad faith. Because first and foremost, the Attorney General must view himself not as the lawyer for the President or the lawyer for the executive. He is the custodian of the rule of law. He is the custodian of public interest, and at all times must act in public interest. Where public interest is at variance with the interest of a small ruling class, public interest must trump that small, narrow interest. And the work of the chambers of the Attorney General is to ensure that we implement the law as it is. If the Attorney General's chambers views itself in that light, there should not be any hesitation, any dithering, any technicality, any advice, because the ruling of the Supreme Court was really, as Prof has said, even comprehensible to a common person. Very clear and direct. The Attorney General should not be issuing any other order apart from transmitting the orders of the Supreme Court for immediate implementation. Trying to read the order of the Supreme Court and interpret it first undermines the ruling of the Supreme Court, because when the Supreme Court has spoken, nobody else should really even attempt to read into what they have said. And I think that the Attorney General should transmit that order for immediate effect and not try to give it some meaning other than the meaning that the court has ascribed to it on order. If I were in his shoes, I would immediately ask all government agencies that are responsible for implementing this order to do so now, immediately, not awaiting some advice from the Attorney General. If I were the Commissioner General of Prisons, I would be very happy to decongest my prison and send away everybody whose warrants have expired, because the Supreme Court has said those trials were illegal. So I think that the actions of the Attorney General are actions of trying to dance a delicate dance, trying to find a delicate balance, especially given the expositions of the President and those in the military circles. I think he's trying to dance a very delicate dance in that regard. And I think that in doing so, he's undermining the office of the Attorney General, but also undermining the decision of the Supreme Court.
Sticking with you, Nick, you were here and we talked about the 65 pages of the proposed amendments that were to come in, that were proposed in December, that were supposed to come in now. It's the 6th advisement that the Attorney General gives, and what Honorable Segona said about Colonel Chris Magezi and the President's letter, doesn't that put us in a very delicate place? And what is that place?
So we have two choices here. The wise choice is to implement the decision of the Supreme Court without question, and do so in absolute good faith, do so expeditiously. That is the wise thing to do. But it seems that we are also either inadvertently or advertently drifting towards a second choice, which is a choice of creating a situation of constitutional and legal crisis. Because the President's letter essentially is telling the judges off, is saying things that are in any ordinary democracy a head of state wouldn't say. So we are heading towards a path of constitutional crisis and a path of further abuse of the rights of people who have been detained on the orders of the General Court Martial. I think for me that's the unwise thing to do. The argument that they will go back to Parliament and undo the decision of the Supreme Court because they want to try civilians. The argument that the General Court Martial is responsible for peace and stability is without basis, either in law or in fact, because I don't think that this country is peaceful because of the General Court Martial. Absolutely not. So I think that the amendments in Parliament, which were proposed earlier in December, don't cover what the Supreme Court has said. If I were the Minister of Defense, who also is a lawyer, the Honorable both, I would immediately withdraw the proposed amendments of the EPDF Act that's before Parliament in view of the Supreme Court ruling. I would withdraw that amendment and take back a new amendment so as to incorporate the proposals and the judgment that was delivered by the Supreme Court. The amendment before Parliament now only does seek to rectify the illegalities that has been happening in the army, namely trying to find a place for the SFC. The SFC is an illegal entity. I think that Honorable Segona and the Honorable Semuju have made this point in Parliament, that the SFC is illegal. What the proposed amendment brought in December sought to do, or is seeking to do, is to regularize that illegality, but does not in any way touch on what the court has said. So if I were the Minister of Defense, what I would do is simply withdraw that proposal and bring a new proposal that seeks to implement and not undo the decision of the Supreme Court. Because trying to undo the decision of the Supreme Court will lead us right back into another legal challenge. Because as you know, Article 92 prohibits Parliament from enacting laws to vary a judgment of the court as between the parties. The Attorney General was a party in this case. In fact, he argued this case himself, personally. He cannot be the same person to come back to Parliament, seek an amendment to undo the decision of the Supreme Court. That would be itself illegal. It would lead us back to a court challenge to that law if passed by Parliament.